Hello students, we conclude this discussion on private international law by discussing the harmonization and unification efforts in the domain area of the subject. Private international law is witnessing a cataclysmic change in the content and manner of its utility, where borders have nearly been wiped out in human relations, physically and virtually. This domain knowledge space is reinventing itself to meet the contemporary requirements of law. The Hague Conference on Private International Law has taken the lead in preparing international instruments to address issues or irritants in the applicable law, jurisdiction and enforcement in matters of interpersonal and commercial disputes. It has made a significant contribution to the harmonization of law in the area of family law, civil procedure and international commerce. In the area of international commerce, it works together with the UN Commission on International Trade Law. The UNCITRAL, headquartered at Vienna and working through its regional centers, the UNCITRAL has made significant contribution to harmonization of the legal platforms affecting business. This chapter explores the convention space in personal laws and commercial law. Personal law, important conventions. Hague Convention on the Recognition of Divorce and Legal Separations 1968. Under the convention, the acceding states, subject to the fulfillment of one or more of the prescribed conditions, recognize divorces or legal separations obtained in another contracting state. Article 1 specifies that the convention does not apply to findings of fault or ancillary orders. On the date of the institution of the proceedings, person instituting the proceedings in a court of a convention country must be domiciled habitual resident there or domiciled habitually resident within that court's jurisdiction for not less than an year. When a legal separation is converted into a divorce in the state of origin, the divorce must be recognized. Convention on Jurisdiction, Applicable Law and Recognition of Decrees Relating to Adoptions 1965. The convention applies to an adoption between a national, habitual resident or spouses, each of whom being the national, habitual resident within one of these states, and an unmarried child who is a national, habitual resident of the contracting states, aged less than 18 at the time of application for adoption. It does not apply if the adopters belong to different nationalities, habitual residences. The adopters and the child, all possessing the same nationality, habitually reside in the state of which they are nationals. Jurisdiction to grant an adoption is vested in the authorities of the state where the adopter habitually resides. The authorities of the state of which the adopter is a national, or in the case of an adoption by spouses, the authorities of the state of which both are nationals. Convention on Celebration and Recognition of Validity of Marriages 1978. The Hague Convention ensures the recognition of the validity of marriages across national borders. Part 1 of the convention deals with celebration of marriage. Part 2 with the recognition of foreign marriages. The law of the celebration approach has distinct advantages. 1. Consent of the parties would be determined by the local law. 2. It avoids characterization problems. For example, The problem of determining whether a parent's consent is a matter of form or of substance. And 3. It allows unusual or oppressive requirements of a foreign law to be ignored. While Part 1 of the Convention is optional and may be excluded, Part 2 on the recognition of the validity of marriage is mandatory. The state of celebration, it is important to note that this may be any state and not just another contracting state, determines the validity of the marriage, and the contracting states are bound, subject to limited number of exceptions and public policy, to recognize the validity of the marriage if valid according to the law of the state of celebration. This avoids the need to review the applicable law in the recognizing state. Convention on Civil Aspects of International Child Abduction. The incidence of international parental child abduction is assuming alarming propositions with the rise in the divorce rate. They have serious consequences for the child and the left behind parent. The child is removed from contact with the other parent and from its home environment and transplanted to a culture with which he or she may have had no prior ties. The Convention provides a system of cooperation between central authorities and a rapid procedure for the return of the child to the country of the child's habitual residence. A return order is not a custody determination. It is an order that the child be returned to the jurisdiction which is most appropriate to determine custody and access. A return decision is not a decision on the merits of any custody issue. The requirements of a return order are that the child was habitually residing in the other state, that the removal or retention of the child constituted a breach of custody rights attributed by the law of that state, and that the applicant was actually exercising those rights at the time of the wrongful removal or retention. The Law Commission of India has recommended acceding to the above mentioned convention amongst others. Commercial law, important instruments. International commerce gains its legal character from a variety of instruments, conventions, protocols and soft law. And there has been a constant updation of regulatory material and processes along with innovations like the International Commercial Court. The harmonization work addressed all the three aspects of private international law: jurisdiction, choice of law, and recognition and enforcement of foreign decisions. The Convention on International Sale of Goods 1980. It applies to contracts between private B2B for the international sale of goods. Parties with places of business in different countries that have ratified CISG, or where parties opt in to choose CISG to apply, even if their businesses aren't in ratifying countries. Example, by choosing the governing law of a country that has ratified CISG. It governs the formation of the contract and the rights and obligations of seller and buyer arising from the contract. It does not govern the validity and effect of contract on property of goods sold. It does not apply to domestic contracts. B2C business sales bought for personal, family or household use. Contracts for services, not mixed contracts where main part of the contract is for labor or services. Sales of certain specified types like auction, stocks, shares of money, ships, vessels, hovercraft or aircraft, electricity, and when parties have agreed to exclude the operation of CISG. While interpreting, courts may refer to the treaty, preparatory material and the resources at the CISG Advisory Council and the case law from CISG jurisdictions during dispute resolution. It is to be interpreted autonomously. Reference to domestic law impermissible. The UN Convention on the Use of Electronic Communications in International Contracts 2005 ensures technological neutrality. Any communication related to the contract, offer, acceptance, statement, demand, notice, declaration, request made using data messages. Functional equivalence of form requirements removes legal hindrances that occur from the insistence of paper form of documentation of the contract. Attribution of communications through e-signatures. Data message, information sent, received or stored by electronic, magnetic, optical or similar means including electronic data interchange, email, telex, telegram or telecopy. Originator is the natural or legal person by whom or on whose behalf the communication has been sent before storage. Addressee, party intended by the originator to receive the communication. Information system, system used for generating, sending, receiving, storing or otherwise processing data messages. Location of the system is irrelevant for the purposes of this convention. Hague Convention on Choice of Court Agreements 2005. 3 core principles. Court specified by an exclusive and valid choice of court agreement must hear the case. All other courts must suspend or dismiss the case. Judgment of the chosen court must generally be enforced by courts in other contracting states. Review on merits prohibited except if it is a default judgment. HCCA removes the problem of forum shopping in international contracts. Presumptive exclusivity. It ensures the enforcement of the forum selection clauses by attributing recognition irrespective of the imperative choice required in a few forums. Convention is not applicable to matters that are subject of national laws, regional and international treaties. Intellectual property matters, employment contracts, antitrust matters, family law and succession, status and capacity, consumer contracts, insolvency, carriage of passengers or goods, maritime matters, nuclear liability and others specifically excluded. UNIDROIT Principles of International Commercial Contracts 2010. International Institute for the Unification of Private Law. Uniform Rules of Contract Law. Party autonomy limited by mandatory rules. Governs all international commercial contracts, wider application than CISG. Applicable to issues such as validity, agency and assignment. Parties contract and perform the contract in good faith. No opt-out provision for this clause. Hague Principles on Choice of Law in Commercial Contracts 2015. Primacy of party autonomy. Parties could choose non-state law also. HPCL applicable only to B2B commercial contracts. The contract to be governed by an express implied choice of law applicable for the whole contract or depackage. Such choice of law could be modified without prejudice to its formal validity or the rights of the parties. No connection required between the chosen law and the parties or their transaction. Choice of law by the parties survives nullity of the main contract unless it is a nullity. Principle of renvoi excluded. Encore Terms. First published in 1936 by the ICC Paris and amended every 10 years, Encore Terms largely relate to the transportation terminology that is part of the international legal platform of business. They are widely accepted in international contracts. They are used for price-related customs valuation and import-export clearances. Currently, 13 Encore Terms are in use. Ex-works, free on board, cost insurance, freight and delivery duty paid are the most frequently used Encore Terms. UCP 600, ICC Uniform Customs and Practice for Documentary Credits 2007. It regulates letters of credit, a common payment method in international sales transactions. Applicable when the credit document itself should indicate that it is subject to the UCP 600. It also contains rules for electronic records. Hague, Hagwisby and Rotterdam Rules. Related to international maritime commerce. There are two types of documents in maritime contracts, a charter party agreement and a bill of lading. Either of them could be utilized for the contract. Different forms of bills of lading presented difficulties. Liability clauses needed extreme care and caution. Uniformity would ensure clarity. Hague Rules, adopted at Brussels in 1924, are a scheme for uniformity of bills of lading, adopting the compromise of the split risk between the carriers and the cargo owners' risks. Hagwisby Rules, 1968. A carrier has far greater bargaining power than the shipper. So, to protect the interests of the shipper cargo owner, the law should impose some minimum freight obligations upon the carrier. The carrier's duties are not strict but require only a reasonable standard of professionalism and care. Some exemptions from liability on a cargo claim include destruction or damage to the cargo caused by fire, perils of the sea, act of God and act of war. The shipper has fewer obligations, namely to pay freight, to pack the goods sufficiently for the journey, to describe the goods honestly and accurately, not to ship dangerous cargoes unless agreed by both parties, and to have the goods ready for shipment as agreed. Hamburg Rules, 1978. The Hague Rules and the Hagwisby Rules were said to be disadvantageous to cargo owning countries and to developing countries in particular. in that they operated to place more business in developed countries, protecting ship owners and also creating double insurance situations where the cargo owner was carrying insurance for liability which was really that of the ship owners, but could not easily be made to stick. The ship owner is exempted from liability for nautical fault and is not liable for negligence in management and navigation. The carrier is liable for loss, damage or delay caused by the fault of the carrier, his servants or agents, unless he could prove that the loss, damage, delay was resulting from any special risks inherent in to the carriage. The carrier is responsible for loss, damage or delay for which a subcarrier is liable. Rotterdam Rules. The Rotterdam Rules apply also to door-to-door contracts under which receipt and delivery may be inland and the loading and discharge of the shipment may be by the sea. Rules apply to the charter party contract as well as the bill of lading document. Under the Rotterdam Rules, the period of application and the period of responsibility of the carrier coincide with that during which the carrier is in charge of the goods wherever he receives and delivers them, except where the goods must be handed over to an authority in the place of receipt or in the place of delivery, an exception that would apply, it is thought, only in port-to-port contracts. It allows for more e-commerce and approves more forms of electronic documentation. It eliminates the nautical fault defense, which had protected carriers and crew from liability for negligent ship management and navigation. It extends the time that legal claims can be filed to 2 years following the day the goods were delivered or should have been delivered. Arbitration of international commercial disputes. Remedying the defects of the Geneva Convention 1927, the New York Convention on the Enforcement of Foreign Arbitral Awards 1958 ushered in a pro-enforcement regime. Arbitral awards given in any convention country shall be enforceable irrespective of a decision on them in the courts at the seat of arbitration. Further, the arbitration agreement shall be enforceable in any jurisdiction that has acceded to the convention. The convention has ensured that awards shall be enforceable per se, and there shall be no review of the awards on merits either at the seat of arbitration or in the enforcement jurisdiction. Enforcement of a foreign arbitral award can be refused only on the limited grounds of the award not being in accordance with the terms of reference or the arbitral tribunal not being constituted in accordance with the arbitration agreement, or that the tribunal has functioned in violation of the principles of natural justice. The New York Convention's success is marked by the fact that it has a current membership of 155 countries. Following the convention, many countries have amended their arbitration laws, but there were problems of disparity and absence of clarity in the provisions of the domestic laws, which led to the increasing litigation on arbitral awards and jurisdiction of the tribunal. To address this problem and to bring in harmonization in the arbitration laws of various countries, the UNCITRAL model law served as an important guideline for states to benchmark their arbitration laws. India's global exposure in international arbitration has seen a surge since the enactment of the Arbitration and Conciliation Act 1996 based on the UNCITRAL model law. It was amended in 2015 to make necessary changes with regard to the jurisdiction of Indian courts in foreign seated arbitrations. Jurisdiction. Indian courts would have a very limited role in a foreign seated arbitration. They can order interim relief only when a tribunal is not constituted, and the tribunal needs to be constituted within 90 days of the interim order. Choice of law. The parties are free to choose any law as the governing law of their arbitration agreement, including non-national law. Trade usages shall apply. Enforcement and execution. The party seeking enforcement of a foreign award under the provisions of the Arbitration and Conciliation Act shall apply to the competent court with the following documents: the original duly authenticated copy of the award, the original duly authenticated copy of the arbitration agreement, and proof of foreign award. When found valid as required above, such award shall be enforced as a decree of the court. Refusal of enforcement of the foreign award. Enforcement of the foreign award may be refused on the following grounds on a request by a party against whom it is invoked, only if it is proved that 1. The parties to the agreement were under some incapacity, 2. The agreement was not valid according to the law of the seat of arbitration, 3. The party against whom the award was invoked was not given the choice of appointment to the tribunal, or sufficient notice of such appointment was not given, or was not allowed to present his case properly. 4. The award dealt with a matter not submitted to arbitration or otherwise contains matters beyond the scope of arbitration, provided that if such matters could be separated from the award could still be enforced. 5. The arbitral tribunal composition was not on the agreed lines of the parties. 6. The award has not yet become binding upon the parties, or it has been set aside or suspended by a competent authority in the country of the seat of arbitration. 7. Enforcement of an arbitral award may also be refused if the court finds that the subject matter of the difference is not capable of settlement by arbitration under the law of India, or the enforcement of the award would be contrary to the public policy of India. A leading case in point concerning foreign awards and their execution is First Day Lawson versus Jindal Exports Limited. The Supreme Court stated that once a foreign award was found enforceable, it shall be considered a decree of that court, and that court has to proceed further to execute the foreign award as a decree of that court. In Sri Lal Mahal Limited versus Progetto Granospa, the Supreme Court stated that review of a foreign arbitral award on its merits is untenable as it is not permitted under the New York Convention. The judgment clearly exposes the difference in the scope of inquiry during the annulment of a domestic award and the enforcement of a foreign award. It stated that the expression Public Policy of India under Section 48 of the Arbitration and Conciliation Act 1996 should be construed narrowly. The court thus continued the work begun in Bharat Aluminium Company Limited versus Kaiser Aluminium Company Limited, where it said that foreign arbitral awards do not have to stand the test of Indian law applied to domestic arbitrations only and will be held enforceable if they were treated enforceable according to the law of the seat of arbitration. To conclude, private international law as a subject has gained immensely from the unification and harmonization efforts discussed above. These efforts are a constant endeavor to ensure a smooth transition in interpersonal relationships and harmonized legal platforms for international commerce.